All right, I want to carry on from a story we had yesterday. We talked to Brooke Van Velden, Deputy Leader of the ACT Party and Employment Relations, Minister, who outlined for us new laws that will better define, some would say, or introduce new tests for whether or not an employee is an employee or a contractor, including 4 key principles, which I cannot recite off the top of my head right now, about what the test is. And the test is that you have a signed agreement that says you're a contractor. The test is that you do not have to turn up at specified times to do things, and that you can subcontract the work that you're doing for someone to someone else. What you do cannot be changed simply because the person who's paying you the money says so, and a number of other things. And I've sat there and I've thought about this story since. What is this all about? What is the real effect, and why might it be necessary? So I thought, rather than take, and I mean this in the most respectful way, the minister's word for it, the person who's preparing the legislation, which will be, I think, done by the end of next year, thought I might go and talk to an expert. Andy Bell's an employment lawyer, and he joins us on the line now. Andy, thank you very much indeed for helping us out this morning.
Oh, good morning, Sean. Thanks for having me.
All right. What are the big changes, if any, to this proposed legislation?
Well, effectively, Sean, what the legislation does is it puts another test in front of the test that's ordinarily used, and that test you've described that it sets out that there needs to be a written agreement, that the worker can effectively compete, so there's no barriers to competition, that they don't have to work at particular times, or they're allowed to subcontract, and that's important, it's and/or, and that the business can't terminate the contract if the worker does not accept an additional task or engagement. So the way that it works is effectively quite a streamlined test that avoids the more difficult and test that has a lot of discretion reserved to judges and authority members, which is a balancing act. And that test takes into account a number of factors that I think Brooke talked about some of those yesterday, but that essentially looks at, firstly, the intention, but then looks at the control that the principal or the employer has over the individual, how integrated that individual is into their business, and whether you can say that they are truly a person in business on their own account. Yeah. So the way that test works is that the discretion is such that you can actually focus in on one of those factors to the exclusion of the others and argue a position that somebody...
Yeah, Andy, I'm still trying to figure out what is the problem that this bill seeks to solve, though?
Well, I think, Sean, we don't actually need to look much further than what we've seen come out of the Employment Court and the Court of Appeal lately. And I think the problem that it solves...
Are we talking about the Uber issue?
We are talking about the Uber issue, and it solves that problem. And I would go so far to say, Sean, that Uber care contracts likely pass this 4-point test. So what it effectively does is it promotes what the Court of Appeal called the platform economy. So for me, it's a specific endorsement that ACT National and New Zealand First, they are looking to include or remove barriers to that platform economy in New Zealand society. So I think that's the problem that they're fixing.
All right. Here is my other question, and I ask these from a naive, non-legally trained or educated viewpoint. If you're not an employee and you're a contractor and you have a dispute with another party, do you have access to the employment courts? Because surely then it's a business-to-business relationship.
No, you don't. In fact, what you would have access to is the district or high court, and I would say that those would be wholly inadequate in my view. there's delays in all our
believe me.
authorities, but in terms of the district court, I think delays would be very significant. You don't have the protections that the Employment Relations Act offers and its other legislation that's associated with it, like the Holiday Act. So it's all purely contractual. So you'll wind up in a situation where you're in the district court arguing the contractual provisions.
So people need to be aware that when they sign, as proposed in this legislation, Andy, when they sign the contract that says I'm a contractor and this gives me certain rights that I can subcontract, I can compete, I can contract to other people and everything. But when they do that, they are also signing away their right to access the employment relations system of justice in this country and dispute resolution. They're essentially contracting out of that protection.
They absolutely are. And beyond that, they're contracting out of things like parental leave, holidays, statutory holidays. So all of that is gone for contractors.